Good afternoon or good day, and welcome everyone. Today's session focuses on key employment law updates that employers in Ontario and British Columbia need to be aware of right now. Some of these changes are already in effect, and others are continuing to roll out this year. If your organization has not addressed everything yet, that's okay. It's not too late. Our goal today is to highlight what needs attention now and help you start 2026 on a solid footing. Today's session is presented by Ashkar Law. We're an employment and labor law firm serving clients across Ontario and more recently, British Columbia. Our host today is Clifford Singh, a partner at Ashkar Law. Clifford has a long track record of advising on employment law matters, including workplace disputes and litigation. He works closely with employers on compliance and risk management. With that, I'll turn it over to Clifford.
Thank you very much, Ian, and thank you everyone for being here today. I hope you find the session as informative as is possible. Why don't we get right into it? 2026, as is the norm, new rules have come along, new changes in the law, but the theme of these rules and changes in 2026 is transparency, transparency, transparency. We're seeing a greater focus on transparency and documentation, a less tolerant approach for informal hiring, recruiting practices, increased complaints tied to hiring, pay, and termination. There's been a greater volume of that the government is trying to address. And courts and regulators really expecting proactive compliance from employers. So we're going to expand on what that means in the next couple of minutes. But the overarching theme I want everyone to kind of have at the forefront of their minds is one of compliance and one of transparency. Those are the two main pillars which undergird these changes in the legislation and reflect kind of the court's opinions on where things are going. So this has been the trajectory historically of how the courts and legislature views the employer-employee relationship, with a significant tilt towards more regulation, compliance, and employee protections. That's been the prevalent theme in the case law, and the legislation has altered and metamorphosized to reflect that approach. So what we're seeing now is the direction of travel is clear, as I mentioned, more transparency. Employers who decide to wait to implement these changes are risking not only internal disruption, but potentially external risk. Pay clarity supports recruitment and retention, and inconsistent practices create exposure. So uniformity and consistency, that's what the government in Ontario and in BC are looking for. So what employers need to start looking towards proactively, as I mentioned, is standard job posting language, role-based pay ranges, can't be amorphous or unclear what the compensation is, and an internal alignment between the human resources component or arm of your company and management. Again, consistency and uniformity in the approach is what regulators and what, if it ends up in court, and what the courts are going to be. We're seeing a similar legislative arc in BC as well, with a push towards lifting the veil, so to speak, behind hiring practices and compensation structures. Specifically, BC employers should understand job postings must include salary or wage information. Again, can't be amorphous, unclear, or hidden. Pay ranges must be reasonable and defensible. I know that's kind of a case-by-case basis, and there's going to be context and color, but one has to take it from a reasonable, objective approach in terms of the pay ranges that are associated with certain positions. Employers have a more onerous reporting and record-keeping obligation. That's part of the changes. Inconsistent pay practices, it increases the risk for employers. So again, uniformity, you're going to be hearing me talk about that quite a bit today. And then it goes without saying, but I'll mention it nonetheless, there can be severe regulatory penalties for noncompliance. And of course, you never want to open yourself up to potential litigation. Even if the litigation is frivolous or vexatious, I tell all my employer clients, you don't want to have to deal with a lawsuit if you don't have to. So get out in front of it in that respect. From the analysis standpoint, the analytical standpoint, the job postings are the first step in that. So if your job posting is in alignment with what's expected of you from the courts and the legislature, you should be on the right side of your employer-employee relationship. For Q2 of 2026, BC employers should be reviewing all job postings and templates. They should confirm the posted pay reflects actual compensation practices, so these numbers can't be pulled out of thin air. They need to align internal pay structures across some of the roles. So again, I don't mean to belabor the point, but uniformity and consistency, That is what is really key with these roles, that there is a very consistent approach to the pay structure for similar jobs. There has to be an identification as to who sets and approves pay. So is it just one individual? Is it a board? Is it a group of individuals? How exactly is that decision-making process undertaken? And then there has to be documentation that supports the pay decision. So these decisions cannot be taken on a whim. They can't be drawn just on the basis of someone's internal thinking process. It has to be papered over and covered. Again, early fixes reduce complaints and rushed corrections post facto. You never want to be dealing with things post facto. What this means practically is that there should be a full vetting by employers to ensure compliance. This can be onerous, it can be tedious, but it's not optional. And running afoul of these new changes can have massive ramifications, which certainly no client of mine want to deal with, and I'm sure no one present here wants to have to deal with if they don't have to. Hiring and recruitment. So let's start from the beginning when you're actually out there looking for talent. This practice has come under increased scrutiny over the last couple of years. Here are some of the risks that employers often run with their procedures and their practices. Informal or inconsistent hiring decisions. There's no consistent pattern behind who is hired, for what they're hired, what they're paid. Poor documentation of selection criteria, use of tools or automation without oversight. I'm going to talk about that in more detail in one moment. Misclassification of workers. We've seen this become a very hot button issue, not only in employment law, but certainly politically, with foreign workers, and inconsistent pay offered for similar roles. So again, hiring is not just an operational issue for employers any longer, it's a compliance issue. And just backtracking to the point in regards to tools or automation without oversight, what we're talking about here is AI, which is arguably the most hot button topic on earth over the last couple of years. And one particular change I want to flag for the employers at present here today is Ontario Regulation 467/24, rules and exemptions regarding job postings. That defines artificial intelligence as a machine-based system that, for explicit or implicit objectives, infers from the input it receives to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Well, what does this mean? It means that employers who are using such tools as automated resume screening, candidate ranking, they have to disclose this information in their job posting. And that's really, really key, because a lot of my clients have started using these tools in the recruiting and hiring process, which is great. We always want to be able to use whatever tools are at our disposal to find the best possible talent. But what I'm trying to impress upon everyone here today is that these new changes, particularly the way artificial intelligence is delineated and defined in the law, has to be at the forefront of these hiring practices. AI can't be used willy-nilly or without, the guardrails that the government has kind of been looking at. So using it is one thing, but using it in compliance with what the government aims are is an entirely different practice. Continuing on with that theme, hiring and recruitment changes for 2026. There's an increased focus on worker classification, as I mentioned. That's been a significant issue with foreign workers. Dovetailing on that point, temporary agency licensing and compliance. I'm sure many in attendance have had to deal with temp agencies and the compliance issues that they can raise in their recruitment, hiring, transfer processes. Signals around technology use in hiring. I just mentioned AI. That's going to be at the forefront of these kinds of issues going forward. And location-based rules affecting layoffs and job continuity. There's been some changes with respect to the layoff periods and durations in Ontario. And in British Columbia, similar approach and trajectory. Pay transparency impacts recruiting, evolving worker protections, and WorkSafe BC focus on psychologically safe hiring. I often find my employer clients, they focus primarily on the additional weight that this puts on the organization to come into compliance with these new rules. What I try to point out to my clients is there's a reputational aspect to the implementation of these new rules. And what I mean by that is being an employer that is out ahead of these changes and showing proactive compliance, it lifts the company's reputation in the eyes of the general public, at least in my experience. What that does in turn is it widens the potential net to recruit better and better talent. So it's not all bad. by being proactive and coming into compliance with these new hiring protocols and demands that's been put on you, you can actually use it as a marketing tool to say, hey, potential candidates, we're in compliance with the law, we're disclosing everything that is necessary to be disclosed. And for that reason, you guys should come work for us. Compare that with a company that isn't doing those things, and the difference becomes very stark. As is always the case, enforcement of these standards, regulations, and laws, that always remains a priority. So vacation pay calculations, record keeping, leave administration, there's been some changes on the leave side as well in Ontario, disconnecting from work policies. We know that the work-life balance has become a hot button flashpoint topic for employers and employees over the last several years. That's something that employers really need to be cognizant of. And monitoring and transparency expectation. All employers, as everyone I'm sure here knows, you owe a duty of good faith to your employees. And the substrata of that is transparency. It is compliance. So your employees know that, hey, my boss is in compliance with the law. They're being transparent and open with me. I don't have any grounds to make a complaint or to cause problems or to disrupt the operation of the business. As the last point in the slide points out, many of these issues, they don't come from a place of ill will or malice. They just come from outdated practices. And that's one of the reasons we're hosting this webinar today, is that so employers can be proactive in getting out in front of these things and getting compliant as early as possible. Similarly, in BC, we're seeing minimum wage entitlements updates. There's expected to be another increase, I believe, in the minimum wage in BC in June of 2026. Leave entitlement changes, strengthen enforcement tools and penalties, so they're making it harder for employers if they do run afoul of these rules, and then psychological health and safety expectations. The compliance obligations absolutely go beyond simply wages and hours. There's a holistic approach being taken by the legislature and the courts to ensure the well-being of employees from top to bottom, not just the amount of time they work and not just the compensation they receive for it. I think the best way to conceptualize these changes is as a cost-benefit analysis. So the potential harm to the company of governmental penalties, labor board complaints, or worst case scenario, potential litigation situation, in my opinion, it far outweighs the initial outlay of time and resources necessary to come into compliance. So if I had to put it in a nutshell, I would say an ounce of employer prevention is worth a pound of employee cure. You might as well deal with it now, because dealing with it later is going to be that much more difficult and could be that much more disruptive to your practice. Pivoting a little bit now to talk about termination clauses. This is an ever evolving area of employment law. And again, hot button flashpoint topic. The termination clause is arguably the pivotal clause in any employment agreement. Courts in Ontario and BC, they continue to attack termination clauses because of things like ambiguous or overly broad language, failing to meet the minimum standards of the legislation, conflicting terms within the same agreement. And I'm going to talk about that a little bit more in detail about how the courts would approach that in one moment, and reliance on outdated templates. Most employers, when preparing an employment agreement, they go back to the template they had for the last employee. Well, perhaps unbeknownst to them, there's been a significant change in the law, and that precedent, that template, is no longer applicable or no longer valid. An unenforceable clause could potentially lead to significant notice liability, potentially damages on top of that. What I like to tell my employer clients to keep at the forefront of their analysis is the principle of contra preferentum. So this is a legal principle that states if a term in an agreement and a contract is ambiguous, it's going to be interpreted against the drafter. And for the purposes of our discussion today, that's the employer. So the last thing you want is a court declaring that your employment agreement is invalid for lack of clarity. Keep that in mind. The respective differences in bargaining power leads the court to determine overwhelmingly that if there's an ambiguity or something's unclear in that contract, they're going to interpret it in favor of the employee and against the employer because of that division in bargaining power, that inequality in bargaining power. So the upshot is ensure that your agreements, and particularly your termination clauses, are compliant with the relevant jurisprudence and the relevant legislation. Now, what should you do practically about contracts? Work off the presumption that they're no longer enforceable. Review the termination clauses early in 2026. Address these issues during hiring and promotions, not after termination. So you may need to alter contracts that are currently in place with employees. That is something that you have to look at, because if in the unfortunate situation you have to terminate and your contract is invalid, you're going to be on the hook for a significant amount of exposure as far as notice goes. And then ensuring that contracts align with current legal standards. We're going to talk about this in depth in our February webinar, but for the purposes of today, what I can advise is that in the overwhelming majority of cases I see with employment agreement around 3-4 years old and older, so not that old, the language is simply not going to hold up to judicial scrutiny. Proactivity is the key here to rectify your contract so there's no risk of an adverse interpretation by the courts should a dispute arise. And that's a legal question. It's not a factual question. So a disgruntled employee, they could challenge it, and then the entire fate of the contract is in the hands of the court. Take it out of the hands of the court, put it in the hands of the company, and ensure your contracts are in compliance, are legally valid, and would hold up if challenged. So just to recap for the employers in the attendance today, review job postings for pay transparency compliance, assess your hiring and recruitment practices, confirm the employment standards compliance, that's your baseline beginning standpoint, and then audit employment agreements and termination clauses. As I mentioned earlier, you want to do a full vetting of your entire organizational practice, really from hiring all the way through termination, and the agreements which form the foundation of the employer-employee relationship. Associated with that are things like your harassment and violence policy, your attendance policy, your leaves policy, and your remote work and monitoring. Again, ensure that all of your protocols, policies, whatever the case may be, in alignment with the law and in alignment with the relevant jurisprudence. In order to do so, you can't rely on innuendo. You can't rely on AI. You do need to speak to an employment lawyer. We're more than happy to assist with these issues. We deal with it every day. But for the purposes of protecting the employers out there in attendance, reaching out and being proactive for legal assistance on this is something that I strongly, strongly recommend.
What is the current status of the at any time language in an employment contract?
That's a really good question. For those who are unaware, there's been a very big dispute over the last couple of years about this phrase at any time in employment contracts with respect to termination clauses. So the language usually goes along the lines of the employer may terminate your employment at any time, et cetera, et cetera, et cetera. What the courts have said is that's not in alignment with the Employment Standards Act. So that kind of language is invalid. Now, what is interesting about that is that there are hundreds of thousands, arguably millions, of employment contracts in Ontario which use that exact language. So this is not only a big legal question, it's a big policy question in terms of the implications that it would have for employers if hundreds of thousands of employment agreements are rendered invalid almost instantaneously. So it's a little bit of a gray area right now. In fact, our office is appearing in the Court of Appeal on this very issue in, I believe, in spring of 2026. And we're hopeful that's going to give some clarity to both employers, but employees as well about what they're signing. So the answer to the question, and I do appreciate the question, is a good one. The at any time language right now, it's up in the air. And, once the arguments are made in front of the Court of Appeal, as I mentioned, our office is on that case. We're hopeful to get some clarity, but it is absolutely going to change the landscape of employee relationships in Ontario. So I thank you for the question.
What are the penalties for not complying with the pay transparency rules?
It's going to be contingent in regards to how egregious the breach is. So it's also going to depend on how far the ministry, the government wants to take it. So that's going to be a case by case basis. That's going to be really contextual with color to determine exactly what the penalties are going to be, because breaches could be minor, they could be inadvertent, arguably, or they could be egregious. They could be very, very gross breaches. So it's going to be on a case by case basis. That's why, in my opinion, a good employer shouldn't even be thinking about what happened if I didn't do this. The mind shift, the phase shift in the analysis and the approach should be towards, I have to do this, and I'm not even going to think about what the repercussions are should I not.
The next one is, how enforceable is a 2-week notice requirement as listed on the employment agreement? An employee resigned without 2 weeks notice.
In cases of resignation, depending on what the employment agreement states, if an employee resigns in breach of their obligation to provide sufficient notice, the question then becomes, well, what can the employer do? Now, in practical application, I have never seen an employer go after an employee for breaching the notice period as far as their resignation goes, either for damages because they breached the contract or specific performance, which is essentially trying to get them to come back to work and work. Generally, when the relationship at that point is so acrimonious that they're not even upholding their notice period, it's probably not in the best interest of the company to either pursue legal action against them for damages or for specific performance. Now, that being said, if the notice period in the contract is significant, let's say you're required to give 4 weeks or 6 weeks or 8 weeks, and that person walks out leaving the company holding the bag, that's a situation where potentially you might want to consider exploring your legal options for breach of contract. If there's provable and demonstrable damages that has been caused by this individual's breach of their notice period and their resignation, then that's something that you should be seeking legal advice on, because depending on the exposure, that's a potential lawsuit against that individual.
Next one is, what are the implications when an employee refuses to sign a new version of their employment contract?
That's an interesting question. So let's start with the issue of consideration. When you are asking an employee to sign a new employment contract, you can't give them the exact same contract essentially without what's known as consideration. So that's something additional on top of what they already are getting. So the typical example I have worked with my employer clients on is give them another week of vacation or another day of vacation. Give them a signing. You have to give them something because what you're asking them to do is agree to new contractual terms. So the repercussions if the employee says, I don't want to sign it, then if your consideration is sufficient, again, it's going to depend on a contextual analysis. But the courts have said that things like additional vacation days, signing bonuses, that's all sufficient. If they refuse to do so, it could be construed as potentially breaching their employment agreement, abandoning their position. Conversely, if an employer is providing a contract to the employee that's new without consideration, that employee could allege that they're being constructively dismissed. So you're changing the fundamental terms or material terms of my contract without giving me something for those changes. That's the consideration I was mentioning. Hence, you're constructively dismissing me. So as is the case and often the case, excuse me, it's going to depend on context. But if your consideration is sufficient, if what you're giving them is sufficient, if you're giving them a $25,000 signing bonus, for instance, and they're a relatively low earner for a new contract, and they say, no, I don't want to, you could theoretically argue that they're abandoning their position, they're resigning. So that'll be a contextual analysis based on the facts. But generally, my recommendation in those situations to employers is give something that a court would have a hard time saying that's not sufficient.
Next question. If my contracts have the old verbiage, like at any time, do I have to give all new contracts? And how would that be presented?
And I do appreciate the question because it's a very live issue. So as I mentioned, the at any time language right now, it's a gray area. There's a world in which the Court of Appeal finds that language to be valid and enforceable. There's a world in which the Court of Appeal finds the language to be unenforceable and invalid, thereby putting the company potentially on skates with respect to exposure. I am of the opinion, to be extra safe, and again, I would recommend seeking out legal advice to have a formal conversation because the contract has to be interpreted as a whole. But I would shy away from using at any time language in my contracts. I would revise them. I was just working with a large manufacturing employer last week. We prepared a contract for an employee who had been there for very long. So we provided another week of vacation. And the termination clause, I did not use any kind of at any time language. I just simply don't want to put that into the crosshairs of an employment lawyer for them to zero in on to argue for their client's interests. So as tedious and as onerous as it is, I would recommend reviewing and altering those contracts to remove that language just in the instance the Court of Appeal comes down and find it to be unenforceable. Then you're dealing with it after the fact, which could be even more problematic. So you have to get the appropriate consideration, and I would not be using that language. Our office or a qualified employment lawyer can certainly assist you with preparing new contracts in that respect.
What level of documentation is now expected to justify hiring decisions if a complaint is filed?
It's a great question because with these new rules and new changes, we don't have an evidentiary foundation for what employers should be doing. So when I've been speaking to my employer contracts, I've advised them to overdocument. I've advised them to paper absolutely everything. Obviously, nothing that could be potentially damaging to the company, but that raises its own issues if your internal documentation is disclosing that kind of stuff. But I would say err significantly on the side of caution, over paper, document everything such that if there was a complaint lodged against you for unfair hiring practices, you have a thick stack of documentation where you could show, nope, there was no untowards practices being implemented, there was no bias, there was no systemic discrimination. The answer really right now, it's evolving, but I don't know how one could go wrong if you document essentially everything with your hiring processes, how you set them up, the implementation or use of AI, all of these kinds of things. I would say that over documenting is the best way to at least start this process because, again, we're still new and we don't have years of data to determine exactly what is required of employers in light of these changes. So over document, over document, over document. It's something I do in my own personal legal practice. I ensure that every conversation, every exchange is logged somewhere such that if there was ever a dispute, it's all papered and I'm covered on.
Is it appropriate to require employees who have been with a company for an extended period to sign an updated contract?
I don't necessarily think the analysis should start with the tenure of the employee. I think the analysis should start with what are the contents of the employment contract, because regardless if the person has been there for a year or the person's been there for 20 years, if your contract's invalid, you're opening yourself up to potential legal exposure. So whether it's a short or a long-term tenured employee, I start the analysis with show me your employment contract you gave to these individuals. And if the language in there is problematic, if the language in there raises concerns, in my opinion, then absolutely you should be giving new employment contracts. I know it comes with the added problem of, okay, now I have to give consideration to potentially numerous employees, dozens of employees. But again, I'll reverse engineer the analysis if a bunch of them decided if you had to terminate or they resigned, constructive dismissal, whatever the case may be, and they brought claims and your contracts were deemed invalid, the exposure would be exponentially more. So I don't necessarily think it's a situation where you're looking at the tenure of the employee. I think it's all about what is in the contract, what does your termination clause say, and is it going to hold up to judicial scrutiny if that arises?
Can employers require an employee to sign a new agreement every year of their employment, despite the fact that their job is exactly the same and nothing has changed? They have been with the company for 10 years. The employer is attempting to avoid, for example, a 10-year notice period termination if they fire you in year 11. Can they do this to try and avoid a 10-year notice period severance?
Generally, the case law, if you're just giving a new employment contract, it doesn't restart the notice period. So if you've been with the company for X amount of years and they give you a new employment contract, but the material duties of your job remain the same, the fundamental responsibilities remain the same, the material terms essentially remain the same, then their previous time is going to be recognized by a court. A court's never going to say, oh, you gave them a new employment contract, therefore their tenure restarts. Now, you could propose that to them, but that could also be construed potentially in a very negative light. Because if I was an employer, I'm going to say, well, wait a second, I've been with the company for 10 years. You want me to sign a new employment contract? Sure, give me the appropriate consideration, but you have to acknowledge my previous 10 years of service. So I actually have a case like that that's going to trial in March, where I had a long tenured employee for over 25 years. A company bought his employer and he was given a new employment contract, and they attempted to not recognize his previous several years of service, which they ultimately relented on. So In giving a new employment contract, the short answer is it doesn't restart the clock on a potential notice period.
If old contracts are being renewed, what kind of considerations should we be looking at, if any?
I don't know what you mean by renewed, but if you are giving your employees new contracts, even if it's a slight change, then you should be giving consideration. And that's going to be contextual. That's going to be on a case by case basis. As I mentioned with the documentation piece, to over document, I would say within reason, give more consideration than can again be turned down, kind of the Godfather principle, make them an offer that they can't refuse within reason. So again, if you're ever in front of a judge, you want to be able to make the argument that, Your Honor, the consideration provided to Mr. Smith in this contract was sufficient for these reasons. So never find yourself where you're back on your heels trying to defend consideration. How do you get around that? You put more than one would expect when presenting this new employment agreement. So over document and provide more consideration than one would expect. And that's where you want to get the opinion of a lawyer on that, because consideration for different employees could look like different things.
What are the reporting requirements around pay equity?
In BC, just by example, there are going to be some reporting requirements that speak to discrepancies in wages between genders, discrepancies in wages amongst marginalized groups. So, as I mentioned earlier, because these are all new changes that are coming into effect, we don't have perfect clarity on those kind of documentary rules regarding pay equity, pay transparency. As I mentioned earlier, I do think overcorrecting, for lack of a better term, or over documenting is your best bet just to ensure that you are in compliance. Keep in mind, the government introduces these changes, introduces these regulations, but they haven't experienced what that looks like on the ground. So both the government and the regulators, as well as employers and employees, we're all living in a new landscape with respect to these changes and how they're going to be implemented and how they're going to be determined. Ministry of Labor representatives, for instance, when doing workplace investigations or dealing with complaints, this is a new landscape, these regulations and these changes. So in order to protect yourselves, again, what I say to my employer contracts is you're never going to go wrong over documenting. You can go wrong, and you can find yourself in a difficult position if there's a dearth of information, if there's a lack of information, if the documentation with respect to pay transparency in and of itself is opaque. That's going to be problematic in the eyes of a regulator. And worst case scenario, it could be problematic in the eyes of a judge. And that's what you do not want happening. Thank you all. And don't hesitate to reach out should you need anything. You can ask me by name. Have a wonderful day.